While the economic freedom fighters and the African transformation movement are in the Constitutional Court today, as you've heard, challenging Parliament's decision not to proceed with that impeachment inquiry into President Ramaphosa over the Phala Phala scandal. Let's now bring in legal expert Elton Hart just to discuss this further. Elton, a very good afternoon to you, and thank you so much for your time. So essentially, the two political parties in the main want the decision by the National Assembly to be declared irrational and unlawful. The party's legal team was earlier expressed, was pressed rather to express the lack of explanation for the delay of this matter 14 months after that fact and after that decision. Could this serve as an obstacle in their latest bid, do you think, especially because the legal counsel for the EFF, we heard earlier on, saying that they cannot, in fact, produce new evidence as they go about their explanation?
No, indeed. So, and I followed the proceedings. So if you look at the first justice that actually voiced this concern was Justice Majid, because he came strongly to say, like, look at the delay. And I think then Justice Matopo followed on that. Justice Teron followed on that. I think Justice Kolapot even came on to that. But the thing is, like, that delay, and the problem lies for the EFF in that the sixth administration, and now you've got this GNU, because the sixth administration was all about ANC, ministers, and then the parliament was a majority ANC parliament. Now we have like sort of half a collection of parties actually getting them over the line to have a majority. So, and the judges or the justices was like saying, you can't bring something that was created by a majority ANC government now to a government of, as they call it, a GNU, to say solve a problem that was created by somebody else. But I think the EFF Council pointed out that the delay should not be the only factor looked at, and the thing is that the responsibilities and the duties does not attach to persons, individuals, but rather to the post, to the position. So the duties attaches to the position of speaker, not to who was the speaker at that time. And he tried and explain to the court that the court should look at it in that way when they say that Parliament had a duty to actually adhere and refer to the panel's report to a committee to investigate, and only thereafter Parliament should have acted and not sort of half abruptly acted and not even giving that leading of evidence, cross-examination of witnesses based on what the panel has said. So that's where the EFF, but I foresee that because too many justices was like hindering on that point of delay and looking at it as an obstacle, a hindrance for them to actually move forward with this case.
There was also that principle being argued on the clash between political allegiance and constitutional obligation. I mean, could we in fact see a decision by the courts returning this matter back to the National Assembly? As you also talk about it, that was, the justices also pointed out that was a matter by the previous administration. In fact, things have changed significantly with the 7th administration, because essentially the EFF asking the court not only to set aside the National Assembly vote, but also to substitute it with a decision to initiate an impeachment inquiry. Perhaps just explain and clarify that for us.
But now the thing is, like, that's the second part of the EFF wanting the court to now instruct the National Assembly. Then we start playing in the principle of separation of powers, because there must be a clear separation between the powers of courts and the powers of the National Assembly as set out in the Constitution. To ask the court now to say to the National Assembly how to run their business, that's now actually sort of half encroaching on that principle of separation of powers. I think the possibility of the court saying to the National Assembly, guys, the 6th administration made a mistake, or the 6th National Assembly under the National Assembly and the 6th administration made a mistake. Please review this and decide how you guys are going to conduct. If you want to amend your rules and fix this. That is a possibility that the court can go to. But to go and say to the National Assembly, this is what we want you to do, that is going to go too far for and reach too far for the court to say. And I could see the reasoning as to how they say that this panel that was started by the Speaker, it is technically an extension of the National Assembly. Now you say your own panel is incompetent or did incompetent work, and that's why you're voting against it, but not even giving reason. So I think that might be a more feasible, a more a palpable solution if the court would say, go back to the National Assembly and deal with this issue back in the National Assembly as per the rules and the code of conduct of the National Assembly.
And Elton, to your recollection, does this case then mark, the first time that rules are being tested in this manner in the apex court? And the rules, written to give application to Section 89 as an example, the party saying that this may be open to political abuse by majority parties, for instance.
No, and that was the debate that happened between Justice Theron and the counsel for the EFF. And obviously, they canvassed the point to say, listen, because if you have a majority, even if something is not good on your books, but because you have the majority, you can just by voting, you can vote a bad thing into something good. So they canvassed that point, and I can understand where they come from with that. And I think this is maybe where we need to look at the rules of Parliament, not so much at the Section 89 proceedings, but more at the rules of Parliament. Because if the rules of Parliament is geared better and actually say, okay, if you appoint a panel, once the panel has made a report, that report should then be referred to a committee. The committee will then bring in the evidence leaders, they will bring in the affected parties, legal representatives, and the evidence will then be tested in a court-like manner, like we've seen with the public protectors 194 inquiry. Then they can test it, and once they come back and that committee now, which is the portfolio committee, says to the National Assembly, there's not sufficient evidence to actually impeach, then that's why they take to, but if that committee comes back and says, there is, and based on 1, 2, 3, and here's the evidence, now they take it to the National Assembly. I can understand that that would make more sense, especially if you look at the heads of Chapter 9 institutions as well as the President when it comes to either Section 194 or Section 89. I think that there is maybe a loophole in the rules that I feel they've got a case to actually sort of test the rules on that aspect.
And what is the deferring argument in as far as President Ramaphosa's legal team is concerned?
The deferring was, but then I think the counsel for the ATM advocate Katz, he raised that issue to say that if they wanted to deal with this deferral thing, why was the ANC MP so quick to vote against the report, and most probably to say, listen, if we're not sure, and if you are saying that there's an investigation pending by the Reserve Bank, by all these law enforcement bodies, why did we not say, let's defer then and wait for all these investigations to be done? Then we have a better spectrum of evidence, or prima facie evidence, or sufficient evidence, because that was also a talking point for the better part of the day. What is prima facie and sufficient evidence? And thereafter, they can then make an informed decision. And that is where they talked about the deferral. And then again, it will go back again to the National Assembly. And then depending on your numbers in the National Assembly, that's the sad thing. If you have got the numbers, then you can again, this cycle can repeat, so it can be a vicious cycle that we'll see more and more of these types of cases come to court. But that is how our constitution, and it's unfortunate that we have proportional representation, and that is what you're going to get in the National Assembly. If you have the numbers, even if something is not good for a group of parties or constituencies, it might be good for the majority.
And just as we wrap our conversation, Elton, perhaps give us a sense of where this case might be skewing towards in its conclusion.
Looking from the questions from the justices, I think that they will find in favor of the President to say that the delay was too long and the harm that could be caused to the President. Because I remember Justice Majid was one of the ones to say that this process, if it gets back and the President gets impeached, it's a serious one, because you lose all your benefits, you lose a lot of things, and it shouldn't be treated lightly. So based on that, for me, it looks like, based on the questions, I think the court will lean more towards the President in this scenario here.
All right, Elton, thank you so much for that. Legal analyst Elton Hart there for us. Of course, we are monitoring that court case very closely, and we'll get a wrap of what transpired in court with our legal reporter later on, Kenny Mapanga.